Before a single word is spoken in this courtroom, understand what's at stake here. This is the Allen case, 2 case numbers, multiple chances, and one final decision that could determine whether accountability means prison or rehabilitation. The state says Mr. Allen burned through every opportunity he was given. The defense says addiction, not defiance, is the real enemy here. An ankle monitor cut off. Community control violated. A mother begging for long-term help. And a judge stuck between punishment and fairness. The question is simple, but the answer is not. When does compassion stop and consequences begin? Stay with us, because this sentencing hearing takes a turn you won't expect.
All right, we are back on the record in the Allen case, 24 CR 42183 and 25 CR 42926. Anything, well, first of all, any reason that we should not go forward with sentence today?
No, Your Honor.
No, Your Honor.
All right. Mr. Harris, on behalf of the state.
Your Honor, Mr. Allen has 214 days of jail time credit that should be applied, I believe, to the 2024 case. Your Honor, the defendant was granted opportunities beyond community control initially in his case in 2024. He violated that soon thereafter. The court granted him another opportunity to be out in the community under electronic monitor. That lasted for a period of 2 days. Under the circumstances, I think the defendant's proven he's not amenable to community control, and we would ask to impose a prison sentence. As far as restitution is concerned, a couple of the pieces of equipment were turned in today. So restitution would be $2,099. That's just for the monitor that was not recovered. And I think that's the only deviance from, that was our last state's Exhibit 8, which was requesting more than that. But Officer Wilson came down and plugged up the equipment. It does work. So we are taking that off as far as the restitution request.
So I'm looking at Exhibit 8. We have the charger and the recharger, both were returned. So we have the restitution being $2,099.
Correct.
This is where the prosecution draws a hard line. The state isn't just talking about violations, they're laying out a pattern. Mr. Allen was given community control, violated it. Given electronic monitoring, and that lasted just 2 days. From the state's perspective, this isn't about one mistake, it's about repeated disregard for court-ordered supervision. And notice the precision here, the restitution amount is narrowed down to $299, strictly for the unrecovered ankle monitor. Other equipment was returned and verified to be functional, so those costs were removed. That detail matters. It shows the court is being exact, not excessive. But the bigger takeaway? The state's argument is clear, rehabilitation was offered and rejected. So now, they're asking the judge to pivot from trust to punishment. Do you agree with that shift?
Okay. Officer Conroy, anything from Community Corrections?
No, Your Honor.
Officer Fisher?
Nothing further, Your Honor.
Sir Elter?
Your Honor, in speaking with Mr. Allen throughout the process of this case, what led to the ankle monitor being removed was he had a drug habit. And that's actually what happened this exact day when this monitor came off, was he was with friends, he took it off to use, knew it was a bad idea, was caught a couple of days later. His issues have been substance abuse. I think you'll note his record, while he does have a record, it's largely nonviolent. It really is what I call self-destructive crimes. He's been very remorseful and very respectful and engaged in his defense in this matter. I think he's a very thoughtful person, and I think the 214 days that he spent in jail have allowed him to regain his sobriety, the clarity of his thought, the degree to which he participated in his defense. As the time has gone on, I can see the light switching on, if you will. And so what we're asking, Your Honor, is to consider a CBCF program for him, some sort of program where he can go get residential treatment, get himself squared, continue on so that when he gets out, he can get a job, he can progress further as he wants to. It's actually been very sincere and caught up in emotion in terms of the circumstances, and he's had the support of his family, who I think would vouch that if he were given the opportunity, they would support him and be his support community. And I would also offer, if he were sent to CBCF, he stay in contact with me, just so that he's got somebody to talk to. So, Your Honor, he's always considered the ramifications of this charge. He thought that it was necessary to take it to trial because of the question regarding the notion of detention. So he's here taking full accountability. He's remorseful. We'd ask, Your Honor, to give him a chance to hang on to the sobriety that he's achieved during these 214 days and to move forward.
The defense takes a very different approach, and it's a calculated one. Instead of denying the violation, they explain it. Addiction is front and center here. The ankle monitor wasn't removed to flee, it was removed during a relapse. The defense frames Mr. Allen's history as self-destructive, not violent, emphasizing remorse, engagement, and the 214 days already served as a turning point. This is a classic rehabilitation-focused argument. Jail brought sobriety, clarity, and reflection. The request for a CBCF program isn't about avoiding consequences, it's about redirecting them. But here's the tension: how many chances is too many? And should progress made inside jail outweigh failures made outside of it?
Mr. Allen, what do you want to tell me?
Yes, in regards to what he's saying, it's true. I've been finding myself to make my situations worse than what they are, putting myself in high-risk situations. And I've been in jail in maximum security for 4 months now. And I've thought about a lot of things. Also, I've been in the law book, obviously. I solely thought that I was not guilty of this crime. And that's the only reason why I took the proceeding the way that I did.
So I don't want to interrupt you, Mr. Allen, but I want to make sure that you understand this clearly. I don't punish people for going to trial. So the fact that we had a trial this morning, there were some questions as to whether or not this specific set of facts fits this specific charge and all that. I don't consider that at all either, for or against you. The fact that we had a trial this morning, I don't hold that against you. So, I don't want to interrupt you, but you don't have to spend a lot of time on that. The fact that we had a trial this morning is not being counted against you.
Yes, sir.
Go ahead.
Like I said, put myself in high-risk situations. I have to change my lifestyle. My lifestyle has played a major part of all the things that's been going on in my life. I've been to prison 6 times. And it seems like every time that I go, that I lose a part of me. But I do take full responsibility to everything that I have done. But what I haven't done is take care of the real problem, and that's my drug issue. And I really need to take care of that. And that's all I need to say.
So here's where we're at, Mr. Allen. I get what you're saying about drug problem, being to prison before. We put you on probation, gave you some rules to live by, and it didn't really go that well. So it seems like Mr. Allen doesn't want you to speak, ma'am. But who is this?
That's my mother.
That's okay. That's okay. All right. Well, let's do this. Mr. Elter, why don't you and Mr. Allen have a seat at council table? Ma'am, why don't you step up to the podium for me? Tell me your name and what it is that you want me to know about this.
Tracy Allen, his mom.
Okay.
If I may say, he's not telling a story when he says he has a real bad issue with drugs. And it seemed like, bad as I want him to come home, I don't. Because I'm afraid he'll do good and then he back out there. And I remember calling his probation officer, whoever it was that was on the case, and I said, do you really think he need to come home with a monitor? I said, because he needs to be in a program, a long-term program. And he thinking, it's hard. I've watched every stage. Every stage. I told his lawyer that, every stage. And I'm his mom. I love him and I support him. But he really does need help. And when you go to jail and you get out, it's supposed to be reformed, but yet they let them out and they're on their own. And then when you get to asking people, it's easy to say, I've never been on drugs. I just know people have. And they'll say, well, you got to want, you do, but you got to keep getting that help that you need. And they'll say, well, we can't help him. We're just here to do this, and he's on probation, and that's it. Now, if he wants help, he can go here and there. It's easy said than done, but I haven't been on it, but I've watched the struggle. I really have. He's not a bad person. He's really not. It's just, it has a hold on him. It really does. That's all I wanted to say.
This is the emotional core of the hearing, and it's impossible to ignore. Mr. Allen admits something powerful. He's been to prison 6 times, and each time, he says, he loses a part of himself. That's not an excuse, it's an admission of erosion. Then his mother steps in, and her honesty cuts even deeper. She loves her son, but she's afraid of him coming home too soon. Think about that. A parent openly telling the court that freedom without structure could be more dangerous than incarceration. She's not asking for mercy, she's asking for real help. Long-term help. This moment reframes the case entirely. It's no longer just defendant versus state, it's a family confronting addiction head-on. What would you want the judge to do here?
Okay, thank you, ma'am.
All right.
So again, Mr. Allen, I get what you're saying. I don't disagree with Mom at all. First of all, just because you're convicted of numerous felony offenses and numerous doesn't make you a bad person. We don't convict people of being bad people. That's not how this goes. You're convicted of a specific crime. The problem that I have is I just can't send you straight to a program based upon your criminal offense, because then I have everybody who I let loose on a monitor is going to cut them off and make a run for it. There's a punishment that is required in this case. The punishment has to be serious because I have to know that people that I put on these monitors are going to obey the terms of them being on the monitor. So what I'm going to do is I am in the 24 case, I'm going to impose 214 days in jail. I'm going to credit you the 214 days that you have already done. I'm going to shut that part of the case down.
In the end, the judge walks a careful line. He makes one thing crystal clear: this isn't about labeling Mr. Allen a bad person. It's about enforcing accountability. The court cannot send a message that cutting off an ankle monitor leads directly to treatment with no punishment attached. So the ruling reflects balance. In the 2024 case, the judge imposes 214 days in jail, fully credited, meaning that portion is effectively closed. The punishment is acknowledged, but so is the reality of addiction. This case highlights a larger issue in